Welcome to BDO's Legal Tech Talk podcast. We're joined by judges and legal professionals to discuss emerging trends, regulatory updates, and the latest headlines. We'll provide tips to help your law firms and legal departments make the most out of legal technology. I'm Daniel Gold, BDO Principal and eDiscovery Managed Services Leader.
And I'm Eric Dirk, BDO's Managing Director of Legal Operations. Let's get started with this episode's exciting discussion.
Welcome back to another episode of BDO's Legal Tech Talk podcast. We are very excited to be joining us today in the virtual recording studio is Professor Daniel Solove. He's a national expert on privacy law. He's a prolific author. He's the founder of Teach Privacy, a leading provider of privacy and data security training. And just in case you haven't heard this as well, his scholarly articles have been cited by the U.S. Supreme Court several times. Over a dozen books have been standard reading in both law schools as well as corporate boardrooms. But what sets Dan apart isn't just the volume of the work, it's really the clarity and the urgency with which he addresses one of the most complex issues of our time: how the law can and how the law must adapt to the realities of a data-driven world. In today's episode, we're going to be exploring the evolution of privacy law, the rise of predictive technologies, the limits of consent, and why the current regulatory frameworks are falling short. We're also going to talk about Dan's newest book on privacy and technology, a project that distills years of experience into a practical vision for what meaningful privacy protections could look like. Dan, welcome to the Legal Tech Talk podcast. We are so happy to have you here.
Thanks so much for having me.
So, Dan, when we have spoken in the past about data privacy laws, one of the things that immediately stood out to me was why data privacy for you, right? Was there this moment or realization that made you feel that this was the issue that you needed to really dedicate your career to? Can you talk about the genesis of how you got so involved in data privacy law?
So it actually began when I was in law school. I knew I wanted to teach law. It was in the mid-'90s, just at the time that the commercial internet was taking off. And I took a cyber law course, one of the first that was given. And I really thought the issues were fascinating. I also thought the internet was here to stay. At the time, there was a lot of talk that this was just going to be a passing fad and the internet would disappear. But I thought, no, that this was going to be big. And at the time, there wasn't a field of privacy. There really wasn't much of a field of cyber law either. But I thought that was probably going to be the field. And so I focused my work on cyber law, and privacy was an issue that was barely explored. There was hardly anything out there. So I thought it was an interesting way to start. And then I was intending to go and write about some other issues in cyber law and teach cyber law. I wasn't planning on teaching privacy. But after doing an article on privacy, a bunch of things happened. One, another professor was hired along with me when I went on the teaching market, and he had a casebook in cyber law. And so I realized he's going to be teaching cyber law, not me. Since I had done some research and thinking on privacy, I proposed to teach a privacy class. And they said, sure, as long as you teach a required first-year course, we'll let you teach this other course. So I said, okay, I'll do privacy. And I put together some materials. I had an unpublished paper in privacy, but all of a sudden I get all these media calls, including from the New York Times, saying, "Hey, you're a privacy expert," and it's pretty exciting to be called an expert when I hadn't even finished teaching a semester, I hadn't even published the paper yet on the topic, and suddenly I'm an expert. So that was kind of neat. It made me realize that there really was a need for this, and the field kept growing. So I did a casebook in the area. I took the materials I made for the class and turned that in. And then one issue after the other just kept arising. And so I don't know exactly when the time turned when I realized, wow, there's enough here that I'll never get to other cyber law issues. I don't need to. There's so much here to explore. I really, hit a really big area. And it was always fun. It was always exciting. The issues were always changing and the field was always growing. So I stuck with it. A lot of surprises and interesting things along the way. When I started, it was before HIPAA. It was before the GDPR, long before. So many of the laws that we talk about today weren't in existence when I started. So one interesting difference is just how much has changed in the law, how much law has been passed, because law is typically very, very slow and moves at the speed of a turtle. But in privacy, it's actually moving at the speed of a hare. It's pretty remarkable how much change has happened. Also, the issues and the terms and everything else have changed dramatically. I remember the days, before the use of the term, AI wasn't really used and talked about that much. It was kind of, they were in the AI winter and no one wanted to talk about AI. And there really weren't, people didn't talk about algorithms. So it's like, what do I talk about? I wrote an article about computer databases, and that was the term. Then there was the term data mining. Then big data became in vogue. Then the use of algorithms and inference was talked about. And then finally now it's AI. And then there were days where everyone was talking about the cloud. Oh my, the cloud. Then there was the Internet of Things. So there's a lot of things that kind of got very, very hot, terms that arose, debates that happened, and continue to happen. So it's remarkable just how fast things have changed, how much has evolved in the law. But also, I think interestingly, and to some extent, ironically, is how much also things have stayed the same. So when I look back and for this project of my book, I look back on some of the things I wrote in the early days. And the things I warned about, are here. The problems that were there then are still with us. They're just more acute. But a lot of all the key concerns and concepts with AI were really present 25 years ago, actually. It's just that AI has made things faster and more efficient. But a lot of the issues and the concerns and the problems were there and are still there. And so I think that's really interesting. It's just this combination of old and new that exists with this. That in one hand, I can tell a story like hardly anything has changed. There were problems back then. I warned you, and now I can kind of say, "I told you so. I told you so." There's a lot of issues that were the writing was on the wall, or the problems actually were in existence, and now they're just worse. On the other hand, there's so much new. There's so much interesting things, so many interesting things to talk about.
So let's stick with that for a second. So you're talking about that a lot of the problems have stayed the same when you look back at, the work that you've done in the early days, but you said, but now they're more acute. So can you really hone in on what were some of those problems? What were you warning the public about in your previous work? But now they're so much more acute. They're here to stay, so to speak. And maybe you said AI is one of the reasons why.
Yeah. So, I was writing in the around 2000, and at that point there was a big debate: should we have a federal privacy law? Hey, here we are again, and we're still having this discussion. There was also the fact I wrote about a problem that I called aggregation of data. That you can take a lot of data, and when you take a lot of pieces of data and you combine them, you can then make inferences about other things that people were not expecting to disclose. And this phenomenon existed 25 years ago, where it was possible to track somebody's shopping patterns, track what they bought at the supermarket or what they bought on an online store, and then aggregate that data to figure out other things about people, like their health or their political beliefs. And that was a problem at the time. And I warned about that problem, it creates a lot of difficulties for the approach of privacy law, which is yeah, okay, let's give individuals control. You can decide if you want to share data. The problem is, how do you know what you're really sharing if that data can be combined and then inferences about data that you didn't expect to reveal now suddenly is revealed? And what we've seen with AI is this is how AI works. A lot of the technologies are taking massive quantities of data, looking for patterns in that data, and then are making inferences about that data. And at the time, too, 25 years ago, I was writing about, concerns about how that data gets used, that it is increasingly used to make decisions about people that have a real impact on their lives, decisions about whether they should be given a loan or credit, whether they are arrested, whether they get a job, and a variety of other things that would impact their lives. And what we see now with AI is the same phenomenon, the aggregation of data then being used to make decisions about people that have a big impact on their well-being, on their lives, on their opportunities. I think what we see now, though, is the algorithms have become more sophisticated. The computing power is much greater. So and the amount of data is much more. So there's so much more data to be used, more computing power to analyze that data. But ultimately, this was still there all the way back then. It just wasn't quite as vast, sophisticated, fast, and the inferences made were not as telling as they are now. A change in the nature of contract that, in the past, you go back in the days before the internet and before software took off, you get a contract and you get like a few contracts a year. You just, okay, here's a contract because you got a gym membership or, a subscription to something. But the number of contracts a person would get in a lifetime, now they get maybe in a week. And it's staggering. And contract laws changed. It's kind of allowed and relaxed the normal rules of contract. It used to be you have to have a meeting of the minds, right? You have to actually really agree to something. Now, companies can say, here are terms, take it or leave it. And it doesn't matter if you read it. It doesn't matter if you understand it. They're just kind of being imposed upon people. And then, the courts just say, oh, yeah, it kind of is, we'll just call it a contract. But it's really not. It's a fundamental, dramatic shift in the way contract law works. And it's not really consent. And I've written about this extensively, and I talk about it in the book. I don't think this is consent at all. This is just a total fiction to think that people are really consenting at all in any which way. And I don't think they can consent meaningfully. So it's not, the answer isn't just, let's use the GDPR's approach and make people affirmatively consent. It's just click a button. So then you put the accept button, on the page, and I think everyone's clicked accept for the cookies, accept for the terms of service. They're not going to read 50 screens. So that's all a farce. And then the other phenomenon you talked about was the privacy paradox. And this is the term for this phenomenon that when you take a poll, people will say overwhelmingly, 90% or more will say they really value privacy. I think it's just almost poll after poll shows people really care about privacy. They say they do. But then when you look at behaviors, it seems to be inconsistent with that because people share data all the time. They don't exercise their privacy rights and access the data and correct the data and delete the data. And so a number of folks will say, well, based on that, talk is cheap. Behavior is really what we should focus on. And it looks like from how people behave, they really don't care at all about their privacy. And so therefore, we shouldn't do anything to protect it. And I write in the book that that's totally wrong. That's a wrong conclusion to draw. And that's because the polls and the behavior are actually two different things. The polls measure how much people value privacy, and people really value privacy. And I think the polls accurately reflect that. The behavior does not reflect the value of privacy. The behavior is a risk calculation. And it's the decision that people make when they decide whether or not to use technologies or share their data with a website or a company or whatever. They're making a calculation. They're looking at the benefits and they're looking at the costs, the risks. Basically, it's simple. Like, should I use this cool app? Should I use this technology? Should I use a smart doorbell? Should I use a smartphone? Whatever it might be. Should I share my data? I'm going to look at what are the benefits to me. And that's really easy to determine, right? Oh, cool. I get this cool thing. It's immediate. I'm going to get it right there. I can easily understand what technology is going to give me. And it's going to give me real great things. On the flip side, it's incredibly difficult, actually, I think impossible for consumers to figure out the risks. And so they're going to choose the benefit when the risks are vague, they're in the future, they don't really know. And so the phenomenon I talked about earlier, where companies can aggregate data, and the government too, can aggregate data and then make inferences from the data. How do I say, okay, should I share my supermarket purchases in exchange for a big discount? Yeah, the discount seems great. Nothing I'm buying at the supermarket is all that telling about me. I don't see what the risk is. So what? So they know that I bought, a particular product or whatever. Who cares? Nothing I'm buying is embarrassing. Nothing I'm buying is telling. The problem is that that data can be aggregated. And then from the data, sophisticated AI algorithms can now determine what my political beliefs are based on my purchases, what my health is based on my purchases, what someone's religion might be based on their purchases, and other things based on the buying patterns that they have. Now, the consumer has no idea, without being an AI expert, without being a computer scientist, without knowing the data that these algorithms are trained on, they're going to have no idea what they're revealing about themselves. So how can they make a risk calculation? And if they don't really know what's going to happen downstream with the data, they can't make that risk calculation. Well, how is that data going to be used 5 years from now? Could be 5 years from now, the government accesses it. 5 years from now, and then you're rounded up, and who knows what happens to you, or it's sent to an insurance company, and as a result, your insurance rates go up, or you don't get a loan based on this information, and you had no idea. It's like, I just thought I was sharing data to get a discount at the supermarket. I didn't realize that these things were going to happen to me with this information. They're going to know this. I don't see how a consumer can make this determination. I'm an expert. I can't even make these determinations. I can't determine, should I share my information or not? Because because I know the known unknowns. And so the known unknowns are, well, first I want to have a conversation with the privacy officer. I need to sit down. The privacy notice tells me nothing. It's junk. It says meaningless drivel that's not worth my time. So I want to sit down with the privacy officer and say, okay, show me your privacy impact assessments. I want to see them. I want to see, because just because you say you do an impact assessment doesn't mean it's any good. I need to see if it's good. So I'm going to look at what you do. Did you capture all the risks? Did you mitigate all the risks? How good are they? I want to see your vendor agreements, because a lot of times it's the vendors that create the problem, and companies could have hundreds or thousands of vendors. I want to, how good are the agreements? How do you vet your vendors? Do you monitor your vendors? I want to know about that. I want to talk about the training. Do you train your workforce? I have a company that provides privacy training. What good are policies if you don't teach the workforce to follow them? So you can have the policies, just words on a page, unless people know what they're supposed to do. So I think that's important, but I want to see how good their training is and how often they train and the quality of their program. And do they do risk assessments, general risk assessments of things? What are the resources for the privacy program? What's the buy-in of the privacy program in the organization, the general organizational culture about protecting privacy? On the security side, they say reasonable security, but what does that mean? I want to know, what do you encrypt and how well do you encrypt it? Do you train your workforce? Do you do penetration testing? There's a lot of things I'd like to know. to know about about all the security with your vendors. That's usually the weak link. So I need to know about that.
But
so
Professor,
yeah.
Professor, let me ask you this though, right? Daniel, what I'm hearing is a screeching halt to all of commerce globally if everybody really truly understood what they're signing off here. And they're not really signing off of anything. So let's think about this, right? What you have identified is something very, very serious and very true. And that is, in summary, consent is a farce. When you are opening up any apps or going onto any websites, the consumer who says that they believe in valuing privacy, but behavior is different, that behavior is, I'm going to scroll down to the very bottom, tap on agree, click on agree, and I'm going to go ahead and do it. That's the behavior that's different. So knowing that there is a very specific contradiction between value beliefs and behaviors, and knowing that consent is a farce, and you talk about this in your work, you talk about notice and choice. So if it makes it such a weak tool in modern privacy regulations, what is the average reasonable person to do, knowing that the average reasonable person doesn't really understand what they're signing off, and the average reasonable person isn't going to get an appointment with the chief privacy officer and ask about what their vendor management system or any of their pen testing looks like?
That's a great question. And my answer is I don't think there's much a consumer can do. And the law, unfortunately, puts all the onus on the consumer. It says, okay, you handle this. We'll let you access your data. You can correct your data. You can opt out of things. You can delete things. But I don't know when to, how do I know when a company doesn't need my data anymore? I don't know. Do I have to constantly ask them? There's thousands of companies out there with my data, and I don't even know most of the companies that have my data. I'm sorry, but I don't have time to become a free proofreader of my records at companies. I have other things to do. I even hate when I go, and go to a website and the cookie banner pops up. Like, do you want our cookies, or do you want to learn about the 5,000 flavors of cookies that we have and toggle on and off each one? No, I just want to see the site. I don't want to think about it. I don't want to learn about cookies. I just want to read what I came here to read. And I think that's the problem. But so what do we do if the law is wrong? It's sort of just throwing it into the lap of the consumer and saying, good luck with that. The problem with the world that we live in now is that a lot of digital technologies and that use data are not, there's no way I know they're safe. No one's looking out for their safety. And I'm not going to be able to become an expert enough to make sure that they're going to protect my privacy in the way that I would like. And so I think the law needs to hold companies accountable for that and do what it did with cars and workplace safety and food safety and drug safety. It needs to do the same with digital technologies. It's got
sorry, I just want to jump back in just to clarify. So what you're saying is there's really, if we had the right privacy regulations in place, there wouldn't be a need for any of this consenting to anything at all, because the government regulations would be protecting the average consumer no differently than milk, cars, drugs, et cetera. Is that what you're saying?
Sort of. I think there's still a room for consent. So I don't think the government should just decide, okay, what's, good for you and not good for you. Just like, there's a lot of choices. And I think we need that for privacy and technology, that ultimately I think, I can consent to, giving the data, but the law should prevent a company then from, deriving, inferring, using algorithms to come up with all sorts of data I didn't intend to give them. So if I give them my purchases at the supermarket, they shouldn't be able to try to now figure out all things about my health when I didn't consent for my health. Regulation can be written based on how technology works, and it's really tethered to the way technology operates. And this is actually how the law regulating electronic surveillance, the Electronic Communications Privacy Act, a federal law regulating surveillance, was built around the way that technology looked in 1986. And Congress hasn't updated it. So it's been almost 40 years. The law is way out of date. The internet, email, all, came after this law, and it doesn't make sense. It doesn't apply in a sensible way because it was built and structured around technology at the time. And a different way of writing the law is to focus more on the goals of, kind of what technology does, how it's used, what consequences flow from it, and what values we want to protect. And so you say the law should define those goals. How the technology works shouldn't matter. It should be that the law is about we want to achieve these goals, no matter what happens with the technology. So an example is there's a law passed in the 90s regulating video privacy. And the law was written at a time where people were renting video cassette tapes. And when the law went to define what's covered, it said video cassette tapes and other similar audio video media, roughly a language that was a catch-all that basically said, we're going to write this not tying it to the particular type of technology today, but we're going to write it so that in the future, we don't know what's going to happen, but at least the same goals protecting privacy are going to apply no matter what is used. And now, that law applies to streaming video and other mechanisms for delivering video, which makes sense. And the law has evolved well and worn much better than the ECPA, the law of electronic surveillance, because it was written in a way that wasn't tethered to a particular technology at the time. And ultimately, that law, the law of video privacy, said, look, we really want to protect video privacy. We want people to be able to watch videos and not worry that the videos they watch and the data is being gathered and sold to others without people's consent.
Well, that's an interesting thought, because we don't have one holistic national data privacy law. What we have instead is we've got this patchwork of state laws that's not a very pretty quilt of state laws at all. They're all very sector specific, their regulations, without having some sort of overarching federal privacy framework. I feel as if there's going to just continue to be the same issue that we're having today. It just seems like, well, other countries are doing it. Why can't we just do it here?
Another problem was that there was talk of doing a comprehensive federal privacy law around 2000. At that point in time, hardly any companies in industry wanted to do it. They were all against it, except for a few. But the vast majority, hated the idea, because at that point there wasn't a lot of privacy regulation. They were excited because they could kind of fall into the cracks and not be regulated, and they hate being regulated. So I think I was, at the time I pointed out, that's short-sighted. That's not, it's better to be well regulated and thoughtfully regulated than to kind of hope that, you're just going to exist in this weird void. It's going to change. The approach that we had in the United States was laws based on certain economic sectors, but the problem is, the sectors aren't fixed. We see that, how the world worked and what business looked like in the 70s and 80s and 90s is very different than how things are now. We have companies that are doing health and video and a whole lot of different mixture of things that they didn't have that kind of mix before. So now we have companies that are regulated by dozens of different laws that are inconsistent with each other. So Daniel, let me ask you this then. So I'm really trying to get at the heart of what this is, because you bring up a lot of historical context, and I think that's really important in this area. In every single aspect, we have figured out a way to govern the minutia. We have done it extraordinarily well. We make people much, much safer in this country. But here we're talking about technology, and it's so funny to me because the technology it's built into all of the consumer goods that we buy anyway, right? But what we're talking about is something almost that you can't touch. You can't drive it, you can't fly it, it's built into it, but you can't do anything with it. And so is it that it's so different than everything else that we just talked about? It's not physical in nature. It's got the ethereal existential feel to the average consumer. So is it that it's not understandable, or is it just plain US politics? Because both things can't be true at the same time, is what I'm hearing you say. I hope that my legacy will be, I changed the conversation. I helped put the regulation on the wrong track rather than going in the wrong direction, doing the wrong things, that it's doing the right things, and that we really have a world where we have good privacy protective technologies. Because I like the technologies. I'm not a hater of technologies. I use a lot of these technologies, and I like the technologies. I just think we need to. Just like I wouldn't want to roll back the Industrial Revolution and get rid of cars, but I think we can do a lot better on that. I don't want to be the kind of George Orwell "told you so" too late, and now you're just saying if only we had listened to him. So I hope that that there's a chance that it's not too late to take a change, to change our direction, to do something, and to regulate privacy well. I think it's still possible, but I definitely think we need a change in thinking and a greater political will. And I hope a little bit more recognition by industry that this ultimately is not going to be a bad thing for them. They might think it is, and they think things like preemption, it's going to be really bad. It'll be better. I wish I could. I think it would have been better off if they around 2000 had, we had a comprehensive privacy law, but they didn't want it then, and I made the argument. Look, it's going to be better for you. You're not going to like the world in 10 to 15 years, but that's too long away. And now they don't like the world the way things are. I think the same argument can be made. I just hope that they'll appreciate it. But it does take some long-term thinking and thinking out of the box, and historical thinking too, to see what is likely to happen.
Well, I think with the dozens of books and also scholarly articles that you have drafted, I think there is no shortage of great insight. It's obviously been cited by Congress. Your work's been cited by the U.S. Supreme Court, as we said on the outset. So I don't think you're hollering into empty hallways by any means whatsoever. It does, in fact, sound like your message has resonated. Before we let you go, I know that you are all over the internet. Can you let our listeners know where's the best place to find you?
Sure. So I have a website. My general website is danielsolove.com. So you can always go there and you'll be able to find my writings, my books. A lot of my writings are available for free, so you can get those. You can also get some of my older books for free. You can download those. The newest book on privacy and technology, sorry, you have to pay for it. It's not too expensive. You can get that on Amazon or on Barnes & Noble or online bookstores. And then if you're interested in the things I do with privacy training, because another hat I wear beyond my professor hat is that I provide training to companies on privacy and end user data security. That training, I provide training for a lot of different companies. The site is teachprivacy.com, and I put out a lot of materials, some summaries of the laws. A lot of this is free, cartoons, and other things that are just information out there. And then, for those who want it, there's training for their workforce on what is privacy and what do they need to do to comply with the vast landscape of privacy laws out there. So my job is to try to synthesize all that and create a way to teach lay people at a workforce what all that means and how it all adds up.
Well, I think that's fantastic. And that newsletter that you mentioned, your website has a newsletter on it, and your newsletter is free as well. So I think that's great. This has been a beautiful conversation around data privacy. This has been very, very insightful. And again, we're very fortunate to have you here. Thank you so much for joining us today.
Thanks so much for having me.
Thanks for joining us on BDO's Legal Tech Talk podcast.
If you're enjoying our podcast, don't forget to rate, review, and subscribe for more episodes.
On BDO.com, you'll find all of our episodes, transcripts, and ways to continue the conversation.
Until next time, this has been another episode of BDO's Legal Tech Talk.